So in addition to being one of Bennett Jones's clients, Michael Shaw is the Senior Vice President of Shaw Lens Inc., a newly formed company, which will soon be introducing software which will allow optometrists to use a new innovative design for lenses that will improve corrected vision for patients without inducing anisoconia. Michael heads Shaw Lens' business operations, in which his duties include managing the acquisition and licensing of intellectual property worldwide. Before Shaw Lens, Michael spent 20 years working as a planner, manager, and creative director at some of Canada's largest advertising agencies, including Cosette, Ogilvy, and Mather. Michael then ran his own agency, Brazil Communications, for more than a decade for clients such as Rogers Wireless, Blacks, and CanWest. Highlights include launching CanWest digital properties, integrated campaign planning and creative for Rexall Pharma Plus, and award-winning direct marketing for ClubLink, Rogers, AIRIA, and Harvard Business Review. Please welcome Michael.
Thank you. So I kind of got to thinking, what would I come up here and tell you, because I'm not a lawyer. And a year ago, I had spent maybe $800 on lawyers in my life, and now I've spent a few dollars more. Thank you very much. And honestly, it's the best money I've ever spent. We made a decision when we launched the company. Just to give you a little bit of a background, my brother is an optometrist and is the inventor of this process of making lenses a little differently. I'm not going to get into the details, but as we had been talking about it for about a decade, we finally, at the beginning of last year, realized this might be a patentable thing. And the question came up, certainly, do we do trade secret, where, as Trent, I think it was, said, do you try and protect it that way and just don't tell anyone how you've done it, or do you go the patent route? And we've made a decision based on a number of things, including marketability, that if we went a patented route, we could say we went a patented way of doing something, that we've got now something that we can leverage a little bit better than if we just say, well, we're not going to tell you how we did it. So in the process of sitting down with Bennett Jones and deciding on using them, and it was a very good decision, I just wanted to give you sort of 3 things that Chris told me that changed what we did, and I think saved us a lot of money in the process. The first one was, you've invented something great, you're really excited about it, you want to tell people. And the first thing he said to us was, just shut up. Just stop talking. And this is particularly true for my brother, who's the inventor and was more excited than anybody. Wait until the patent's filed, and then you can talk about it. Prior to that, don't do it. The other thing you want to do is you're doing trials and you want to sell stuff and you want to get some sales revenue going. So you kind of want to get out there, and it's a great thing. And his other thing was, don't sell anything. As soon as you sell it, you can't patent it. You're going to have issues in certain jurisdictions. And I think the third thing that Chris said, it was on the first meeting that we had, we were negotiating with a manufacturer at the time. We're not manufacturers, we're simply the inventor and the marketers for this product. And in the working with the manufacturer, they had suggested that they would be happy to put some money in for the patent process on the understanding that they could co-own the patent. And I remember Chris saying right then, it was, no, you're not doing that. The co-ownership is the same effect as ownership. There's no need for anybody to consult with anybody else on the ownership of that patent. So you're essentially just giving it away for the sake of, $15,000, $10,000, the shared patent costs. So we kind of, I don't know what else to tell you about sort of the legal side of this. We've as Donald has mentioned, the commercialization, looking at licensing is very important to us, and we're exploring that in a number of different jurisdictions and looking at a number of different models on how we're going to commercialize this. Likely Asia will be different for us than North America will be. In terms of, I like what you said about the NDA and that being about licensing, and I realize that's one bit of money I haven't spent with you guys yet to make for me. So I don't know who's going to do that one. But we have, sort of corporately have really appreciated that doing it right and going through a legal firm and getting it done hopefully in advance, although the medical devices they're going to have to look into, is certainly worthwhile doing over than the cowboy way that I would usually do it, which is being a marketer, we just kind of go forward and just do whatever we want and don't worry about the legals behind you. I think that's about it. So thanks very much. Any questions? As was mentioned, I'm a serial entrepreneur. This is probably my 7th company in various fields, so from advertising through retail before that, and this is a new venture for us, so this is a lot of fun. Thank you.
You can also ask the questions to anybody in the panel, including Michael. Yeah, Nick.
Michael, in your case, in this particular instance, you have this hardware and you can demonstrate that there are benefits, correct? What about a situation in which you've developed an idea and but you need to implement it to show that it actually is marketable? That flies in the face of some of the advice you just mentioned.
Well, it's so getting the business model done and proving that it's a valuable product before you go to the expense of doing a patent power. That's really a legal question, and I guess you guys can answer that one. But on my understanding, what we've done is, some of what we've done has been beta, and we haven't told people that that's what they've been buying from us. And we've kind of we've done it and done the tests ourselves. But we haven't sold the product, if you know what I'm saying.
Well, sorry, if I could just add to that, really, I'm interested to know what Chris's answer is to that, but what you raised is a really interesting question, because often there are inventions that you really want to get a proof of invention. You know, you want to do a clinical trial in this case to say, well, does it really work before I go to the expense of protecting the intellectual property, you know, which is a very interesting thing. So you know, what are the some of the guidance you might provide, Chris, around the balance between having to do the validation, proof of concept for the innovation, as opposed to the disclosure, the protecting it as a trade secret and a confidentiality set?
Yeah, in terms of whether it works, I guess the two angles to that. In terms of the strict patent requirement, what you describe as an invention needs to work at the end of the day. In certain areas, such as pharmaceuticals, you need to put in proof that it works in the patent application. If you're talking about, will it work, the business venture, am I going to make money off this? That's really a business risk that you're taking in advance, just the assessment of what your market is and how successful it's going to be.
The risk might also depend on the nature of the invention, because there's a difference between testing what the invention does and whether it will be marketable and well received by the market that way, and how the invention does it. And the patent might protect how the invention does it as opposed to the end result.
I understand that. The reason I'm asking the question is the value of the company, or the idea of the implementation, will be directly affected by the acceptance in the marketplace. I mean, it may be a great idea in theory, but unless I can demonstrate its viability in the marketplace, then the value of the invention, and it is a unique process, is up in the air. There's no way I can easily monetize it until I find whether there's a market. And that I'm having a problem because of the conflict between the need to maintain secrecy and at the same time trying to prove its viability for commercial purposes.
Right, and that's where non-disclosure agreements can help. Once you file, you really have the choice of whether you want to disclose or not. If you don't disclose, the patent office isn't disclosing either, and you can keep it confidential. You can disclose your invention after you file it. You're not gonna lose any patent rights over that. And you can selectively disclose by using an NDA and say, well, I'm going to tell you what it is. Here's my patent application. If you sign this document saying that you're going to keep it confidential.
That point about releasing information after the patent has been filed, but you know, if you're filing in multiple countries, you've only filed in, say, 1 or 2 to start with, then you don't want to release any information, because that would then compromise successive filers, wouldn't it?
Well, that's where the priority rights come in. So in my talk, I talked about the Paris Convention and also PCT filing. So if you're using the Paris Convention, you can file in Canada today, and then a year later file in the US and claim back to today. So even though you filed the US application a year later, it's going to be treated as if it was filed today. And so if you do that disclosure tomorrow, that's still after the effective filing date of the application.
So now, is that true in pretty well all countries in the world?
I would say nearly every country you can think of that you want a patent in is subject to the Paris Convention. Yeah.
If there are no more questions, I will request Dominic to come and
Thank you very much to Michael for addressing us and his personal experiences. I just wanted to say on behalf of Bennett Jones that it has been an absolute privilege to address you. We hope that you found discussing the legal aspects and the personal aspects of maximizing the value of IP assets useful. There was a question about whether we sometimes publish white papers or other topical discussions or bulletins, and we do on issues of IP, IT licensing, etc. And if you're interested in receiving those by email, please give any one of the speakers tonight their card. I'm sure Michael will pass them on to one of the Bennett Jones lawyers, and we'd be happy to get those to you. I just want to say that we are proud of our breadth and depth of experience as individuals certainly, but even more so collectively in all areas. And so if you come to a point where you need some legal advice and legal assistance, I do hope that you will think of Bennett Jones. And again, thank you very much for your patience and for your attention.